On the record in the matter of the people of the state of Michigan versus McQuarrie Powell, 24-02220, counsel appearance.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people. First making a motion to practice under Michigan Court Rule number 8.120.
Motion is granted.
Your Honor, Bobby Fickle on behalf of defendant and fellow Powell.
My understanding is that there was a concern about Ms. Powell needing to get to work.
Yes, Your Honor.
Okay. Ms. Powell was not able to clear this time with her employment.
Unfortunately, that's not an option. I have a set schedule Monday through Friday. There's no ifs, ands, or buts about it. I work from home, so work from home expects me to be there on the dot. But I was able to pull a few strings this morning with my supervisor to get more of a leeway before I have the clock in.
Okay, I recognize that. I mean, anybody who has a job, when you're supposed to be there, you're supposed to be there, whether you work from home or in person. Actually, if you work from home, it should be even more flexible. If I work a shift at the hospital, I can't work, I gotta be there on time, right, to relieve the other person. However, if I have court, or if I have a doctor's appointment, or if I'm going on vacation, or whatever, I put in a request for time off. And so you're saying your request for time off was denied?
You don't put in requests for time off. It's either you have PPA to take it off or you don't. And if you don't have PPA, then you figure it out. Basically.
Okay, and so you obviously did not notify your employer that you have a court date.
Right.
That's the issue. But you want to take a felony plea today, which means you're gonna have to do what? Notify your job that you've got a felony conviction. You want to reset this?
No, we'll move forward today, Your Honor.
Okay.
I asked Ms. Powell just come in today. Take care of this morning.
Well, she'll have to take off more time to go to court. She doesn't know that, correct?
That's correct, Your Honor.
Yeah. Okay. In order for you to take a plea and a felony plea, that is, in the district court, I first need to understand that you understand your right to have a preliminary examination and that you're willing to waive the examination. So you have the right to require that the prosecution put forth sufficient probable cause in the district court and that the crime was committed and sufficient probable cause to charge you with the crime. You understand that? And you want to waive your examination today? Is anybody threatening you to get you to waive your exam? Promise being made in exchange for you waiving an exam. Bind the matter over to the circuit court. Okay, and so I don't think I appreciate what counts is she gonna be pleading to?
Count 3, I thought we turned in a plea sheet last week.
You still need to put it on a record for a felony plea. You have to put it on the record for a felony.
I apologize. Yep, sorry. So, Your Honor, the defendant is going to plead guilty to count 3, assault with a dangerous weapon or felonious assault in exchange with HYTA status. In exchange, we'll be dismissing counts 1 and 2.
That's accurate, Mr. Fickling.
It is, Your Honor.
Okay. I do have an advice of rights and plea information sheet. That's your signature, ma'am.
Yes.
And do you waive the reading of count 3? Counsel, she's gonna waive the reading of count 3.
Yes, sir.
Actually, no, we need to read count 3. We're gonna waive the reading of count 1, 2, and you'll read count 3, the reading of that on the record.
Yes, Your Honor. Count 3 is assault with a dangerous weapon, felonious assault. Count 3 states that the defendant did make an assault upon Kiana Smith with a dangerous weapon, to wit, brass knuckle knife, but without intending to commit the crime of murder or to inflict great bodily harm less than murder, contrary to MCL 750.82.
Raise your right hand, ma'am. And do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, again, count 3 is commonly called a felonious assault or assault with a dangerous weapon. You understand that charge? And you wish to plead to that charge?
Yes.
You understand that that charge carries a maximum possible penalty of 4 years and or $2,000 in fines, and that a consecutive sentence may be imposed if the assault was committed in a place of confinement.
Yes.
Are you currently on probation, parole, or on bond for any other matter?
No.
Okay, because if so, your probation or parole or bond could be revoked by entering this plea. Do you understand that if you are on parole, your sentence for this offense is required to be consecutive to your parole sentence? Okay, you also need to understand that if you're on bond for another matter, your sentence for this offense may be consecutive to the sentence for the offense for which you are also on bond. You understand?
Yes.
If you've ever been convicted of a felony in the past, you could be subjected to penalties, excuse me, as an habitual offender. You understand that?
Yes.
And there are rights that you will need to give up in order to plead guilty. You had an opportunity again to review your rights and rights form,
Yes.
and that is your signature.
Yes.
Okay, so you understand that you have the right to have a trial by jury.
Yes.
You have the right to also waive the jury trial and have a trial by judge if you wish. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove your guilt beyond a reasonable doubt at trial. You have the right to have witnesses against you appear at trial and the right to question these witnesses against you. You have the right to have the court to order your own witnesses to appear at a trial. And you have the right to remain silent at your trial and not have silence be used against you in any way. You have the right to testify at trial if you wanted to. You do understand that if you give up these rights, or you would have to give up these rights in order to plead guilty, correct? Okay. You also give up the right to make any claim that the plea was entered as a result of promises or threats that were not disclosed today on the record. Okay, so there's been no promises or threats. You will give up the right to claim that it was not your choice to enter a plea today. You understand that? You understand that any appeal of your conviction and sentence would not be automatic, like by right, but instead you would have to file an application for leave to appeal, meaning application to have permission to appeal. You understand that? Okay. You understand that you will be given up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Okay. Will you state any agreements that were part of this plea?
Consent to HYTA status, Your Honor.
And that's a full and accurate statement of the plea, Mr. Fickley?
Yes, sir.
Okay, and that's your understanding as well, ma'am? Okay. Were there any promises beyond that plea agreement? Counsel?
No, Your Honor.
You have already indicated, but I'll ask you again, has anybody threatened you to enter a plea, ma'am? It's your choice to plead guilty today,
Yes, ma'am.
and are you pleading guilty because you believe you are guilty?
Yes, ma'am.
Tell me what you did to make you guilty of the offense of assault with a dangerous weapon.
I put my hands on it.
Your hands are a dangerous weapon?
I had something on my hands when I touched it.
Tell me what you did.
I had brass knuckles on my hands and I hit it. Well, I have brass knuckles on my hands, but when I actually put my hands on her, I did not have them. Let me clear that up, but
Okay, who's her?
Kiana,
You know her last name?
yes,
Okay, okay, so you put your hands on Kiana Smith how? To give her a hug?
I punched her.
You punched her. At the time that you punched her, was it in self-defense?
No,
Okay, and you said you had brass knuckles at the time you punched her?
I knocked on the window with brass knuckles, but when I came into contact with her, I did not have them on. It was just my fist.
I don't, that's not an assault with a dangerous weapon. Yeah, further questions? Because I don't have enough for assault with a dangerous weapon, based on what she's saying.
Oh, okay. Ms. Powell, when you were wearing the brass knuckles, did you intend to hit Ms. Smith with the brass knuckles initially?
Yes. But go that way. I just took them off before we actually came in contact with each other.
You had them on your person, what made you take them off?
I thought about it a little bit further. I just thought about it, just took them off, because I knew he was gonna come into contact with something. I really didn't know if he was actually gonna go that route, but when I realized he kind of was, or I was at least at that point, I took them off.
Did you have any other weapons?
Not on my person.
That's something.
I popped the knife in the corner.
So that's aware of the weapons that you had?
No. What was she seeing on my hand?
She saw the brass knuckles.
She did.
Help me understand, how did she, you approached her with the intention to fight? Is that what you're saying?
Yes,
Okay, with brass knuckles on?
yes,
And she was where?
in the car.
Okay, the window was up?
Who's up?
Okay, and so how did you all get to a place where you could actually punch her?
He jumped into the driver's side of the car. She reversed, and I don't know if she wasn't her car, so I don't know how the door got unlocked, but the door got unlocked, and that's how we came in contact with each other.
The door got unlocked
Of
and
the
that,
car.
okay. You're missing some facts. The door just, you don't just come and you're outside the car?
I'm outside the car.
Yes, just the
And I was-
door getting unlocked. Who opened the door?
I did.
Yeah, that's what I need to hear. And what did you do when you opened the door?
I punched her.
Okay, but you, in the middle, was words being exchanged during this? So all this is going on, you're trying to fight somebody, words are being exchanged, you approach with brass knuckles, but all this is going on, and you want me to understand that you took the time to think about it and said, hey, I'm gonna take these brass knuckles off.
Well, it was a lot of back and forth for a while, so it wasn't like it happened quick. When I first approached the car, I knocked at the window with the brass knuckles on. The door was locked.
And said what?
Get out the car.
Okay,
Exactly what I said. So you called me out, I'm here now, get out the car. And we was going back and forth, she was on live, she was talking, just a lot of back and forth, back and forth.
said she was on live, like live streaming, is what you're saying?
Yeah, Facebook Live.
Okay,
And so it was a lot of back and forth, like I said, it was going on for a minute. And somehow she climbed over to the driver's seat, she reversed. At that point, she hit my vehicle. So then in the midst of this, I'm in my car at this point too, trying to move my car. At this point, I'm trying to go. 'Cause obviously she didn't want to fight, but.
so when she reversed, you said she hit your vehicle and you were in the vehicle?
Yes, because I had got back in my vehicle, but it's a dead end. So when she got in the driver's side and reversed, she put it in drive and hit my car. I'm in my car at this point. So at that point, that's when I took the brass knuckles off. I guess I don't know if I was just driving. I didn't want to drive with them on, but I took them off at that point
Before you got back out the car?
before I got back out the car. And then when I got back out the car, this is after my car was hit. When I got out the car, I was hit, and then it's kind of like everything just went from there.
Any other factual basis? Any questions from the prosecution?
Yes, Your Honor. Ms. Powell, when you approached the car with the brass knuckles knocking on the windows, would a reasonable person have felt in immediate fear of being assaulted with the brass knuckles?
Yes.
We're satisfied with the factual basis, Your Honor. I think we have enough for a reasonable apprehension of fear for the victim, Smith, at this point.
Okay, but I'm concerned because she said the door was locked and the window was up. How could a reasonable person be apprehensive?
Your Honor, I think she's testified to the fact that the door did come unlocked at one point. She did go inside to punch her at that point.
She had already, based on her testimony, she had already been in her car. The victim allegedly backed up and hit her car. She's already removed the brass knuckles. So at the time that she's knocking on the door, telling someone to get out, her testimony said the window's up and that the door is locked.
Yes, Your Honor, I understand your point. I think we have a reasonable apprehension of fear still here on the record. However, I think we also potentially have a factual basis to the higher charge of carrying concealed weapons in count 2. So I do think that there is enough to still take this plea, given the factual basis that exists for count 2 carrying concealed weapon, which is being dismissed as a part of the plea, but we do have a factual basis.
Okay, so we can, unless there's an objection, listed a factual basis for that. That she pleads to assault. Is that what you want to do?
Yes, we can do that here.
Okay, you understand what just happened now? Counsel?
Your Honor, I think we're okay with the factual basis for count 2.
Okay. Just so that the record is clear, she's pleading to count 2 now, or you just accept, you're listening a factual basis as to count 2, but she's pleading to count.
In briefly discussing with Mr. Figman, I believe he's, by his count, I'll let him speak for himself, but I think we could do a plea to count 2.
Mr. Fickman.
Yes, Your Honor, we're okay with doing the plea to count 2 and dismissing count 1 and 3.
Yes,
I need you to read count 2.
yes, Your Honor. Count 2 is weapons carrying concealed. The defendant did carry a dangerous weapon, with brass knuckles, concealed on or about his or her person, contrary to MCL 750.227.
Okay, and then Ms. Powell, you understand count 2 as a maximum penalty of 5 years or $2,500 in mandatory forfeiture of the weapon or device, correct?
Yes, ma'am.
The court is satisfied with the factual basis that was elicited as to count 2. Counts 1 and 3 would be dismissed for entry of a guilty plea to count 2. I will also state here on the record that the court has not agreed upon any sentence with anyone involved in the case. Counsel, are you aware of any promises, threats, or inducements for this plea other than what was disclosed on the record?
No, Your Honor.
No, Your Honor.
Does counsel believe that the court has complied with Michigan Court Rule 6.302 and the local administrative order allowing felony plea in district court?
Yes, Your Honor.
Yes, Your Honor.
The court will find the plea to be accurate, voluntary, and the understanded plea made. This plea is accepted. The case is going to be transferred to Judge Dragonchuck for sentencing. Your sentencing date is December 9th, 2024, under the circuit court case number 24-000808 FHC 30, okay? You need me to repeat that, Mr. Ficklin?
Yes, sir.
24-000808 FHC 30.
C30.
That's correct.
Thank you. Did you get the time for December 9th, John?
I did not. Let's see who tells me the time. I don't see a time.
Okay. I'll follow.
You'll get a notice in the mail. It just says December 9th. It's in front of her.
Okay.
Oh, she has a notice?
Oh, okay. Thank you.
Very good. Okay. Do you have any additional matters for the record on this file?
Nothing from the people.
Nothing from the defense, Your Honor.
A bond as set will continue. And good luck to you, ma'am.
Thank you.
Thank you, Your Honor.
You're welcome.
Might be.
People online here.
It looks like we got left here. Thank you.
Okay, he is present. Okay, I have, let's see, Michael Bryant, or Brandt, that is, on the record in the matter of the people of the state of Michigan versus Michael Brandt, 24-02836. Appearance, please.
Good morning, Your Honor. Appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Grant, who appears for the Ingham County Jail today.
Today was the date set for probable cause conference for police officer assault, retail fraud, habitual second. How are we proceeding?
Your Honor, it is my understanding at this time that we're leaving the set. I understand there is an adjournment with good cause for next week. We were notified yesterday. Mr. Brandt, we were notified by the Ingham County Jail, I believe it was late last week, is in need of surgery on his wrist that is currently in a bandage, I think soft cast, they would call it. I did submit, prosecutor I spoke yesterday and submitted a stipulation to ask the court to consider reducing his bond with PR bond to allow him to be out. He is scheduled for surgery. It has been scheduled and confirmed by Captain Earl at the Ingham County Jail. I believe it is either for tomorrow or Monday. I cannot recall which, but he indicated that it would be helpful, I believe is my understanding from that email, if he were out so we could go to that surgery.
Yes, Your Honor. That's my understanding.
I received an email from Captain Earl. Okay, so his bond was originally set at 5,000, 10%. It says that he is. It's just a schedule for surgery shortly after the hearing. When is the surgery?
The jail could not say, for security reasons, they were not able
Okay.
to tell me for sure. My understanding from Captain Earl was probably the day after. is what I
Oh,
understand.
Yeah, they just put shortly after in there. I have no problem amending. PR with Tether so that he can have his surgery. Oh, it looks like we filed a motion. Bond will be amended to 5,000 personal recognizance. I'm not going to impose a tether at this time. Mr. Brent needs to remember to stay in contact with you, because obviously things could change. I'm going to find a cause because I am having a week-long exam next week. So Mr. Brent, you have the right to have a preliminary examination within 21 days of the date that you're arraigned. But because of the court's schedule and proceeding in another matter next week, that will take possibly the entire week. I have to find good cause to go beyond the 21 days so that I can reset your matter. You're having a surgery, and so we also don't want you to be extremely uncomfortable or under the influence of anything when we reschedule this. So I don't know exactly how long it needs to be reset. I'm gonna give you the next available date. You will be in contact with him prior to that. And so if for some reason it's not good to go that date, we can reschedule it,
All right,
okay?
yes, sure. And you said that you weren't going to have the tether after all?
I'm not
Yeah,
imposing.
I was concerned because of the surgery. I was concerned with the tether being on. Thank you.
November 14th. November 14th at 10 is your next court date. Do you have any questions, Mr. Brand?
Oh, Your Honor. No.
All your other bond conditions will continue. Any additional matters for the record?
Nothing from the people.
That was November 14th at 10 a.m.
Yes, ma'am.
Thank you. Nothing further. Thank you.
Thank you. You're all set.
Thank you.
Thank you. Mr. Etheridge is representing Smith to tell us what we were doing.
Smith and Booby, I did see an email on Smith that we were leaving it set for preliminary exam. And on Luby, Your Honor, it's going to be a referral to Veterans Court. I've discussed with APA Randall Berman the process of that. It's gonna take a little bit of time.
Where is Mr. Etheridge? Is he- Okay, well, I need someone to stand in, so I gotta find a cause on this.
I can stand in for him.
Okay, on the record in the matter, the people of the state of Michigan. Versus Joshua Smith, 24-02782, council appearance. There you go.
Good morning, Your Honor. Casey Markarian appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Joshua Smith, filling in for attorney of record Derek Etheridge.
Okay, Mr. Smith, my understanding is that you've already counseled with your attorney and that he is requesting that we continue to exam on this. That's your understanding?
Yes, Your Honor.
Okay, so you were scheduled to have that exam on the 10th of October. However, the court schedule will not allow that. And so I need to advise you of your right to have your exam within 21 days of your arraignment, unless you wait 21 days or the court finds good cause. Due to my schedule and holding another matter next week, I need to find good cause to move your date beyond the 21-day timeline, okay?
Yes, Your Honor.
So we're going to reset this. November 14th at 10. Have any questions?
No, Your Honor.
Any additional matters for the record?
Nothing from the people.
Nothing from the bench. Thank you.
You're all set.
Thank you.
Thank you. You said Jason Luby is here? Okay, on the record in the matter of the people of the state of Michigan versus Jason Patrick Luby, 24-02872, council appearance.
Morning, Your Honor. Casey Markarian appearing on behalf of the people.
I need someone to fill in so I can find the cause.
Sorry, I'm not.
Sorry, did you put your appearance on there?
I did not, Your Honor. Assistant Public Defender Aaron Schroeder, on behalf of Mr. Luby, filling in for attorney of record Derek Etheridge.
Yes.
All right, thank you.
Okay, Mr. Luby, my understanding is that you've already met with your attorney, Mr. Etheridge, and he wants to continue to exams that I think.
Your Honor, this one is going to be a referral to Veterans Court, so
Oh.
people would be requesting a reset for that purpose. Mr. Luby does have a conviction out of Texas that we need to obtain a police report for to see if he is eligible for Veterans Court. I have spoken with APA Randall Berman at our office, who's in charge of those referrals, and we're working on that process. I think we would need probably at least a month to get the reports from Texas, review them, and do the referral.
Okay, did you hear what was stated, Mr. Luby?
Yes, ma'am. Good.
Okay, and so due to your screening and because the court has another matter that's going to take place next week, I'm going to find good cause to go beyond 21 days so that I can reset your exam, okay?
Thank you, ma'am.
Okay, I need contact information for you. What's your email address?
It's my first and middle initial. It's J as in Jason, P as in Patrick, L as in Lima, U as in umbrella, B as in Bravo, Y as in Yankee. And it's at gmail.com.
Okay. At Gmail, okay. And your phone number?
512-765-2199.
Okay, and so we'll make sure your attorney gets your number, okay?
Thank you, ma'am.
Okay, let's see, we'll reset this, you said a minimum of 30 days?
Yes, Your Honor, that November 14th date we've been setting things for might work.
November 14th at 10:30. I will continue. Any additional matters for the record?
Nothing from the people.
Nothing for the.
Thank you. You're all set, Mr. Luby.
Thank you, Your Honor.
You're welcome.
Okay, sorry about that.
No problem. You're free to go.
All right, y'all have a good day.
Thank you. Okay. Mr. Goodrich is here on the record in the matter of the people of the state of Michigan versus LaPriest Stitt Nathan, 24-02841. Council appearance.
Good morning, Your Honor. Case of Mark Arian appearing on behalf of the people.
Goodrich from the Public Defender's Office here to represent Mr. Stitt Nathan, who is standing to my right.
Priest, the defendant.
Okay, let's see. Today was the date set for probable cause conference. I have carrying concealed weapon, felon in possession, felony firearm, habitual fourth offender notice. Are we continuing to examine this?
Yes, sir.
So, Mr. Stitt Nathan, you were originally scheduled to be before the court for preliminary examination on the 10th of this month, because you have the right to be or to hold your preliminary examination within 21 days of the date that you're arraigned, unless you waive the timeline or the court finds good cause. So because I have another matter that's going to take up next week, I'm going to find good cause to adjourn this beyond 21 days, okay? We'll get you a new date.
November 14th at 10:30.
November 14th at 10:30. We'll get you a notice to appear. Do you have any questions?
No.
Okay, the court will get Or Bond will continue. Any additional matters for the record?
Nothing from the people.
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set.
Mr. Stitt.
Mr. Stark is here. On the record in the matter of the people of the state of Michigan versus Stephon Carter, 24-02508, counsel appearance.
Morning, Your Honor. Case Markarian appearing on behalf of the people.
Good morning, Your Honor. Jacob Sarge IV, Assistant Public Defender, appearing on behalf of Mr. Carter. We're both appearing by Zoom this morning.
Mr. Carter, you can hear us? Mr. Carter, please start your video.
Say yes.
Can you hear me, Mr. Carter?
Yes,
Can you go up closer, Stephon?
yes.
Today was the date set for a pre-trial. I'm sorry, not a pre-trial, a probable cause conference for larceny in a building. Mr. Sards, you've counseled with him.
Yes, Your Honor. Mr. Carter requests his preliminary examination is currently scheduled. It's my understanding Your Honor is going to be adjourning the prelim on good cause grounds due to a scheduling conflict. Thank you.
Okay, so Mr. Carter, you understand what we just said?
Not entirely. No.
You don't understand?
No.
Say no.
Yeah, who was in the background telling him what to respond?
I'm sorry, ma'am. He speaks really low and I want him to go up closer. I'm his mother.
Okay,
That's
well, how old is he?
Oh, he's 33. He has some mental issues and I just want you to I'm just telling him to go closer. That's all, ma'am. I'm sorry.
Okay, that was gonna be my next question. Is there a reason why he would not understand how to proceed on his own? And so, Mr. Sarts, you didn't have a concern about his mental capacity?
Your Honor, for the purposes of competency, he is under a lot of direct care, and it's my understanding that he understands how a preliminary examination works, and that he understands that the court is just going to move the court date. That is all today. However, that is a situation we are monitoring in terms of competency, Your Honor, specifically. I'm not saying that mental health issue won't be an issue down the road necessarily, but for today's proceedings, in terms of competency, we are simply requesting that the matter be left on for a preliminary examination. Thank you.
Okay, I need Mr. Carter to be able to respond to my questions without being prompted by someone else what to say and or do for me to understand that he's competent.
Understood, Your Honor.
Mr. Carter, did you understand what your attorney said?
Yes,
Okay, and so you understand that the court's gonna move your court date to another date because of my schedule?
yes.
Okay, the court's gonna find good cause due to another matter of proceeding, and we'll reset this for an in-person preliminary examination.
All right.
November 15th at 9 a.m.
Thank you, Your Honor.
No problem. Any additional matters for the record?
Nothing from the people.
Nothing further from the defense, Your Honor. Thank you.
Thank you, you're all set. On the record in the matter of the people of the state of Michigan versus Frank Andrews Stevens, 22-03370, counsel appearance.
Assistant Attorney General Luann Lemmerman on behalf of the people.
Good morning, Your Honor. Assistant Attorney General Dan Grano on behalf of the people.
Morning, Your Honor. John Moodhart on behalf of defendant Frank Stevens.
Don
Frank
Passenger.
Stevens here, Your Honor.
Sorry, Frank. Don Passenger, P39384 on behalf of Mr. Stevens also.
Okay, this was the date that we reset this for a probable cause conference. The parties were trying to still work through some discovery issues and seeing if this was a matter that needed to still continue to an exam. If you can give me an update as to how you want to proceed.
I can do that for you, Your Honor. Thank you. Councils were in a breakout room just prior to this, and we are working on a plea. And if I could just state that for the record, the defendant has been offered, the people will dismiss counts 1 and 2. He would plead guilty to attempt count 3 under MCL 771.1 for 1 year. During that time, he would pay restitution of $33,900 to the state. We've recently offered for that payment to be made in installments. If at this point the defendant may or may not be disputing that amount, but that's one final detail. And then if Mr. Stevens completes the delayed sentence successfully, including the restitution, the people will amend the complaint to one of 2 90-day misdemeanors at the sentencing date. So that's what has been offered, and what appears that we may be able to get that finished and resolved. But in the meantime, there are some issues. Mr. Stevens having recently been served his sentence. There's some issues about any consequences potentially of entering into this plea. So we're asking that if Your Honor would be so inclined to set this for another PCC in 4 weeks, that will give the defendant some time to resolve their issues, and then also a chance for my office, frankly, to approve this set of the plea agreement. And then at the same time, at a date at your discretion to set it for the preliminary exam, to set that date.
October 31st. Is October 31st at 9:30 work?
Is that for the PCC?
Yes.
I'm afraid I'm going to be out of town. I'm sorry, I guess I didn't think that through. The 4 weeks.
No problem.
That date works for John Moodhart.
Okay, does November 8th work? Because it looks like it doesn't work for the 8th.
That date also works for John Moodhart, Your Honor.
The 8th, that's fine with me.
November 8th at 9 a.m.
I'm still working my way there, Your Honor. I apologize for being slow. I'm actually involved in as a speaker with the Michigan Court Officer Deputy Sheriff's Association that day. So I may have difficulty getting there depending on the time frame. If it's by Zoom, I might be able to do it later in the day, assuming I could get reasonable connectivity where their seminar is located, which is, I think, Crystal Mountain or something.
Yeah, this is for a probable cause conference, so it's definitely by Zoom. And so you're thinking if we move it to later that day, that'd be helpful for you?
Yeah, something probably early afternoon would work.
At 2. Does 2 p.m. work?
That will work for me.
Yes, Your Honor.
November 8th at 2 p.m. works for everyone?
Works for Moodhart, Your Honor.
Yes, Your Honor.
Okay, very good. So we'll do November 8th for a probable cause conference at 2 p.m. If we need to set it for an exam, we'll do so at that date and time, okay?
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. No problem. Bond will continue. Any additional matters for the record?
Thank you.
No, Your Honor.
Just everything that's in place relative to bond appearance and whatnot continues, of course.
You're all set.
Thank you.
Thank you.
Thanks.
Thank you. Hello.
Hi, to verify the Michigan authority.
Okay, let's see. That's Mr. White. I don't see Mr. Milks. Sorry? I don't see Mr. Milks. He's representing Mr. White. Let's see, on the record in the matter of the people of the state of Michigan versus Mario Tremaine Scott, that is, 24-02634, counsel appearance.
Morning, Your Honor. Case Markarian appearing on behalf of.
Morning, Your Honor. The public defender, Aaron Schroeder, on behalf of Mr. Scott. Mr. Scott is present and now standing to my right.
Okay, Mr. Scott, today was the date that was scheduled for a plea, and it says that the defendant is going to plead guilty to amended count 1 of weapons, firearms, improper possession of a firearm in or upon a motor vehicle under Michigan compiled law 750.227D. That's a misdemeanor, 90 days and or $100, and forfeit the weapon or device. That's complete and accurate?
Yes, Your Honor.
Yes, Your Honor. My understanding from speaking with counsel who covered last time we were here, Mr. Freeman, it's going to be a plea with the factual basis for the original charge. Thank you.
Have an advice, right?
That is on me, Your Honor. No, we do not. I will address this right now. Thank you.
Yes. You need the file. You need the file.
Any questions?
And Megan just said Mr. Mills is downstairs talking to the client of hers.
Thank you. Yes, there is now an advice of rights form on the approach, Your Honor.
Yes, thank you.
Case number on it, I apologize.
Thank you. Sure.
Yes, Your Honor, I apologize. I'm straight now, I'm done finally. Thank you.
That's good. Okay. Mr. Scott, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Okay, so in order for you to accept the offer to plead guilty to the amended misdemeanor of weapons, firearms, improper possession, you would have to understand all of the rights listed here and be willing to give them all up. You understand that? You read this document? You understand the rights?
Yes, sir.
That's your signature?
Yes, Your Honor.
You want to give up these rights in order to enter the plea to the amended charge?
Yes, Your Honor.
Okay, so you understand that you have the presumption of innocence and you're innocent until proven guilty, that you have the right to require the prosecution prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to subpoena witnesses or have the court subpoena witnesses to testify for you at your trial. You have the right to waive silence at trial and testify for yourself. You understand that? You have the right to cross-examine or question any other witnesses the prosecution intends to call. You understand that?
Yes.
And you want to give those rights up.
Yes.
Anybody threatening you to do that?
No, Your Honor.
Any promises being made to you in exchange for you entering a plea to the amended charge? Are you on probation or on parole?
No, Your Honor.
You understand that by entering a guilty plea, it could result in a conviction that you may need to report to your current or future employer. It also could have impact on travel status or immigration status that you may seek. And it's also a requirement that you forfeit the weapon or device. You understand that? As to the amended charge of weapons, firearms, improper possession of a firearm in or on a motor vehicle, how do you plead? Factual basis.
Thank you. Mr. Scott, back on September 4th of 2024, were you at or near an address of 1002 Lake Lansing Road? And that address is located in the city of Lansing, County of Bingham, state of Michigan? And in that time, you were moving out of an apartment, is that correct?
Right.
All right, and there, at some point, someone had called the police due to a dispute going on between you and your landlord?
Right.
And the officers responded, correct?
Right.
And there had been, in the phone call, there had been a report of a firearm. Do you recall hearing about that?
Yes.
Okay, and so the officers came over and they got talking to you and they ended up patting you down, is that correct?
Correct.
And at that time, got upset at some point and you pulled out of your pocket a bullet, is that correct? No, he was patting you down, he found the bullet, I apologize. Yes, he felt something, the officer felt something during the pat down and you said it was fine for you to go in the pocket and pull it out?
Right.
Okay, and that was a bullet, correct?
Right.
It was a couple shell casings and then one live round.
Right.
And you have been previously convicted of a felony, is that correct?
Correct.
And that you have not gone through the process of getting that, I guess, back, for lack of a better way to put it, your firearm or ammunition rights restored, is that correct?
Correct.
All right, so you were not supposed to be in possession of any ammunition, correct?
Correct.
And you were in possession of a bullet, correct? All right. Your Honor, the court or the prosecutor, any further questions?
Any questions from people?
Yes, Your Honor. Mr. Scott, the prior felony you were convicted of, it was a conviction for controlled substance delivery and manufacture of marijuana or its synthetic equivalents on March 22nd of 2006 for that. Thank you, Your Honor. I have no further questions. People are satisfied with the factual basis.
The court is also satisfied with the factual basis. I'll accept your plea and find your opinion made free voluntarily and intelligently.
Or is open to it, I'd ask for immediate sentencing.
Yeah, I was going to ask if there's any objection to immediate sentencing.
Okay.
I am reviewing your criminal history. I don't see anything since 2018. I was licensing. You can make allocation.
Thank you, Your Honor. Mr. Scott was cleaning out an apartment. He was being evicted, apparently. He had some things from a junk drawer that he had shoved in his pockets in the process of this. And he had not thought about the fact that this was something from years ago that he just picked up and kept and shoved it in his pocket. And the police ended up there and he ended up here today. He knows he wasn't supposed to have it. And he has brought money with him today to pay any fines or costs as well. And I would just ask the court at this time to sentence him to some type of low fine or cost to this matter. I don't, Mr. Scott, they searched his house, they searched him. There were no firearms found on him or on his person. And I'd ask the court to allow him that opportunity just for fines and costs. Thank you.
Fine is $100. Can you pay that today? Any additional matters for the record?
I think that's done.
You're all set.
Take care of yourself. And then can he, once you both have paperwork, process, he will pay the window?
Well, we're gonna take him right over there right now.
Perfect. Thank you, Your Honor.
No problem.
Wait for the lady. Who will take you down. Here.
Okay, on the record in the matter of the people of the state of Michigan versus Henry Shotwell, 24-02916.
Morning, Your Honor. Jennifer Lawton on behalf of the people.
Good morning, Your Honor. Attorney Marcus Baldori on behalf of defendant. Sorry.
Sorry, should I repeat?
That went bad. It's got two attorneys. Let's see here.
Yeah.
Okay, Zoom first.
Good morning, Your Honor. Sorry for that. Yes, Attorney Marcus Baldora on behalf of defendant. I sent a stipulation for substitution to an email, maybe didn't get there yet.
Appearance for the record.
Stephen A. Freeman, Assistant Public Defender, on behalf of Mr. Shotwell.
Did you sign a substitution?
I have no knowledge of any substitution or another appearance. I have had no communication from Mr. Baldori, not even the courtesy of an email. So I'm at a loss to explain to the court.
Your Honor, I don't have any knowledge of a substitution either.
When did you send a substitution?
I emailed one to pd@ingham.org. If I apologize if that's incorrect, or I was going to ask for a more specific email if I could get one. But yes, just trying to accommodate, and sorry if I didn't send it to the right place.
Okay, so he's represented by Mr. Freeman. Mr. Freeman, what's your email address, or how do you want him to contact you to get you a copy of the substitution?
Thank you, Your Honor. It's S for Stephen, and then the last name Freeman, Freeman, S Freeman @ingham.org.
Perfect. I will send that promptly. Sorry for any confusion.
Okay, sounds good. And once that's signed, it can be sent to the court, and then we'll have your appearance on this record. So today was the date that was scheduled for probable cause conference. Was it the intention to continue to exam on this?
It would be my, in as much as counsel is not yet filed, it would be my preference to go forward with preliminary examination, understanding the court's schedule for this week.
Okay, sounds good. Mr. Balduri hasn't gotten any discovery, I'm sure, so he can't really make an opinion on this.
That's correct, Your Honor. That's what I was going to say. I also haven't spoken to Mr. Baldori. I have not conveyed any offers to him, so I would like to have a conversation with him at some point. But we can do that prior to an exam date.
May it please the court?
Yes.
Thank you very much. I have run into this before, and I would respectfully move the court to inquire of Mr. Baldori, his representations of filing an appearance or substitution notwithstanding. There's a distinction between, has he been retained? Because if he's going forward on a promise to be retained, that is different than if he has been formally retained, entered into a fee agreement, perhaps a retainer fee having been paid, then I'd feel much more comfortable.
Okay, Mr. Balduri, please.
Yep.
You can respond.
Happy to answer that. The answer is yes, been formally retained. I did email my formal appearance over to the 54A district court email. I understand I did not have the full signed substitution form able to be, I was not able to email that over because it's not signed yet, but the answer is yes.
Okay. Yeah, we won't do anything with a formal appearance because you have to substitute. So
Understood. Understood.
Once that's signed, then we can get that entered. I'll note that in the record. And there's time to flesh this out because I have an exam next week that's going to take five days straight. So because of that, the court was going to find good cause anyways to adjourn this matter.
I can just state, Your Honor, we were going to request a waiver of the 21-day rule to whatever extent I'm allowed to make a limited appearance today. That was going to be our request.
First at 9 a.m. November 21st at 9 a.m. is the new date for now. That's for exam.
Perfect.
Did the prosecution need to put anything further on the record?
Nothing further, Your Honor. I will be in touch with Mr. Baldori prior to that date.
Thank you. Anything from defense counsel?
Nothing further, Your Honor.
Nothing further. Thank you.
Thank you. Bond will continue. You're all set, Mr. Shotwell.
All right, thank you, Your Honor. I apologize for the confusion.
No, it's no problem. It's not your problem. It's not your fault. Thank you. Okay, let's see here.
You did it.
And then we're waiting for Mr. Milks. So that he can tell me he's gonna do it, Mr. White. Mr. White, we're just waiting for your attorney to, he's speaking with another client, I believe.
Okay, who is my attorney?
Mr. Milks? Stephen Milks?
Okay. I don't even know who he is. Why, I've seen him and talked over nothing.
Your attorney's gonna log in to speak with you.
Thank you. I'm gonna walk in.
Mr. White,
Yes.
your attorney's computer died, so you'll continue to counsel with him at another time. He's in the courtroom now, though.
You see me, sir? I apologize about that.
Oh,
I'm
okay.
trying to be rude. All right.
On the record in the matter of the people of the state of Michigan versus Archie White, 24-02491, counsel appearance.
Morning, Your Honor. Case Mark Darian appearing on behalf of the people.
Hey, good morning, Your Honor. Stephen Mills on behalf of Mr. White. Mr. White appearing via Zoom at this time for the probable cause conference.
Okay, Mr. White, you have a exam that's scheduled for a controlled substance possession on October 10th at 9 o'clock in the morning. Are we expecting to continue?
Yes, Your Honor. At this time, there has been a plea offer extended on both matters, Your Honor. So we are in receipt of that. I explained that to the client as well. So at this time, though, we would like to leave it on for preliminary examination.
Okay, so Mr. White, you have the right to have your preliminary examination within 21 days of the date that you were arraigned. And you're currently scheduled to have it next week. However, the court, and you've heard me tell several people this, the court has another matter that's going to be going all week next week. So because of that, I have to find good cause to adjourn your matter, okay?
Okay.
November 14th.
Can I speak?
November 14th at what time? 10:30. At 10:30. Do you have something that you'd like to share?
Yes, I'd like to apologize to you, to the court for my contempt. I thought it was the day after the day that my court, because I was in contempt on this.
Okay, well, let's hold off because there hasn't, at least to my knowledge, there hasn't been contempt charges brought or you're. Let's just hold off right now. I don't want you to say something that's going to get you in trouble, buddy.
I'm assuming he's talking about special.
Because I was on the tether for this case. I had a warrant, that's why I was picked up.
That's for your other case, sir, that you have next week, not this one.
Okay, I was speaking on this, I was just apologizing to you for not.
Okay, so you don't have any, you didn't have any contempts or any, you did fail to appear for arraignment on this. I don't know what happened with that, but I do know that you did see the magistrate, she arraigned you and you got this court date. So whatever you're talking about, I'm not familiar with because I don't have your other file in front of me. I do know that your other file is scheduled to have an exam next week as well. We have to reset that. So we'll reset it November 14th as well? Yeah. To November 14th at 10:30, okay?
If we come to a resolution.
Do I have a bond?
Hold on, sir. Hold on one second. If we come to a resolution that includes a district court plea, will we be able to schedule that at a time earlier, like on a Tuesday or something?
Yes. Okay, so like your attorney just said, if you all come to a resolution that involves a plea, we can schedule that sooner, okay?
Okay.
You have a question, sir?
What's the resolution?
We don't know. That's what you all are still working through.
And there's, I don't know, I talked to you, I'm just now talking to you. But right now, do I have a bond? I'm in the county jail.
Yes, your bond was set at 1,000 cash surety.
Okay, so.
And your other file, the other file, you do not have a bond.
Right. So, sir, hold on. Okay, we're gonna address this. Okay, you and I will see what we can do. Okay.
Okay, when will we address it?
Monday.
Okay, thank you. I don't know.
Okay, any additional matters for the record?
Nothing from the people.
Nothing from the defense. Thank you, Your Honor.
Thank you, sir. You're all set.
Thank you.